Welcome to the Law in the Streets. Today we are dealing with the tips to paper 1 and 3 of the attorney's admission examination. Previously we focused on the wills paper, wills and estates paper, but today we're dealing with paper 1 and 3 of that examination. As I've said before, board exam is not difficult. It needs a person who's organized. It needs a person who has a plan. It needs a person who knows what they're doing. And some of the tips that I've compiled here, they will show that these are some of the things that have been overlooked, and there are some of the things that cost some of the people in this examination. One thing that you must note in this paper, that is paper 1, you must know that the paper is divided into 3 subjects. That is personal injury claims, that is the road accident fund, criminal procedure, civil procedure. An important tip to note is that you must not study these subjects consolidated. In other words, do not consolidate them when you study them. You must separate them. Then you are able to see how many concepts have you covered in each, and you will be satisfied that indeed in this subject I've covered 50%, here I've covered 50% or 60% or whatsoever. But if you consolidate them, you are likely to cover 20% in one, 10% in the other, 5% in the other. So it becomes difficult for you to master how far you have went when you were studying. So it's very important that you know at least 50% of each paper in this way. For road accident fund, know that you have to be familiar with when can one hold RAF liable. What are the types of damages, those special and general damages, and who can sue for those damages, and who can sue RAF for those damages. When and who is eligible to recover damages from RAF using the AMA guidelines. You must know those guidelines on and how they are applied, and also know all those standards, all those tests that are applicable in these claims. You must know when to apply the RAF Act and the other acts. Sometimes they may give you a scenario where they say a person was injured at work, but on the road, not necessarily at work, but he was injured while at work on the road. So you must know which act is applicable and when and how, and what happens if they pay a person, COIDA pays a person. Can RAF also pay the person on top of that, or what is going to happen? Are they going to pay a set-off and all that? You must know also that. You must know the procedure to lodge the claim with RAF and dealing with the objections that are inherent there. You must know the prescription on hit and run claims and claims where the driver is known. So you must know the difference between the two. And you must know how the days are calculated, the DS. And also know the forms that are involved. Now, this is all that, if you know from the top of my head, if you know from RAF that you have prepared this, you will cover almost 50% of those questions that will come there for RAF. On criminal procedure, know the types of bail, know how to mitigate sentences and aggravate them, know the issue of drafting of a plea of guilty and a plea of not guilty. Know the issue of access to that information that is in the police station, the police docket. Know the ways to secure the attendance of an accused person trial, those written notice to appear, arrest, etc., etc. Know the implications of closing a case by the state and by the accused. If they close their case, under what circumstances can they reopen their cases? And know also the issues of discharge. Know the options that are available to the accused person at the close of the state's case. Know the issue of confessions and admissions. Know the articles that the police are allowed to seize during a search and seizure. Know the use of force during arrest and the arrest in general. Know the vehemence that have to be made in a charge sheet and objecting to a charge. know how to draft a notice of appealing a sentence and a conviction. This is some of the 50% questions that always pop up there on criminal procedure. On civil procedure, this is one of the most important subjects that people try to just gloss over and all that, and you cannot do that. It's really difficult to memorize these things. You must just know them. The first thing that you should know in civil procedure is Rule 6 and 18. Rule 6 of the Magistrates Court and Rule 18 of the High Court. Here you must know the rules that relate to the drafting of pleadings generally. What do these rules do? When you serve a person with summons, or they look at your particulars of claim and look at that rule. That rule will tell them if a person is alleging that there was a contract, written contract, they must attach it. It will tell you those things. If a person is using the NCA, what is it that they must do? It will tell you all those things. So you must know those rules. You don't need to memorize them, know them. You must just know what are the things that are there. Because sometimes a question comes also, they say, name the things that have to be included in the particulars of claim in terms of Rule 18, rules relating to the drafting of pleadings general. So you must know those things. Averments that have to be contained in the POCs, you will know because you have read the first one. Drafting of notices. Kindly take notice that the applicant will on this day apply for make an application to court for an order in the following terms, blah blah blah. You must know that clause there. If you know one, you are able to know that. Those are mostly there for interlocutor applications. These notices, they'll just say just draft, don't draft the headings and the addresses and all that. They'll just say just draft the relevant notice. So you know that if it's an application to compel, you are able to draft a notice, because that application to compel normally, it's either it can be interlocutory or an application on its own, depending on what you are compelling. But you know an application to compel is, so you know what you are compelling a person to do. That thing which is the first thing in the prayer, the costs, the whatever and everything. And if you want to include days, within days from the date of this order, they must file whatever you are saying you want. So those notices, if you just know few, you are fine. You can draft any notice, even exceptions as notices, you can do that. But drafting of notices of motion, you must know that a notice of motion, the long form, is like summons. Notice of motion, the short form, it's an application that we use inside proceedings that have already been instituted. So the long form is like summons, you must know, but normally they will not ask you to draft those addresses and those other further take notices. That you must just know drafting notice of motion. If they say draft a notice of motion to obtain a provisional order of sequestration, this is just in insolvency. Then you must know the purpose of pre-trial. Additionally, when you know the purpose of pre-trial, you must also know when will the pleadings be considered to have been closed. Then you must know the documents that are used to apply for default and summary judgment. Then you must know the rule relating to summary judgment. That is Rule 14 in MC and Rule 32 in HC, that is High Court. So you must know that this rule has been amended. If you have not been to law school or you are not familiar with rules and all that, you must know that when you study previous question papers, this rule has been amended. So you need to use the current rules that talk about summary judgment after a person has filed a plea, not summary judgment after a person has filed a notice of intention to defend. That is not enough to apply for summary judgment. You must wait for a plea and then state that the defense they raise in their plea does not raise an issue for trial. And unlike before, when they will file a notice of intention to defend and then you will say there is no, they're defending solely for the purpose of delay, etc., etc. Then you must know the exceptions, Rule 19 MC and Rule 23 HC. So, exception you must know also, it has been amended as well. The rule has been amended. Today, you must file an exception within 10 days from the date on which you receive the pleading. So, if you try to raise an exception outside that period, it's an irregular step. After you raise exception still, you must afford the other party 15 days to remove the cause of complaint. When that 15 days lapses, you have 10 days to set it down. If you don't set it down within 10 days, exception lapses. So these are the kind of things that you must be familiar with. Irregular step, rules 60A and 30A. This one, you raise it against a step that you find is irregular. If a person files summons that are not signed by an attorney with the right of appearance or an advocate in the High Court, that's an irregular step. So, non-compliance with the rules, irregular step. Then you must know how to deal with rescission of judgments, apply in there. You must know the documents that you will need to attach property of someone, etc., etc. So these are all the things that you need to know for paper 1. And in my view, I think if you know these things, you'll be able to get a pass mark. Now let's look at paper 3. For paper 3, attorney's practice. Some people call it ethics. I don't know why. This is not ethics. It's not ethics. Ethics, in fact, it's also one of the subjects that are involved in this paper. This is attorney's practices. Everything that an attorney is expected to know. And so if you are already saying it's ethics, if you have not been at law school, in fact, it's worse. Because then you will not know the drafting of commercial contracts, you will not know commercial litigation, you will not know a lot of things. So you will need to work harder when you study because you don't have some of the manuals regarding certain things. So on paper 3, attorney's practice, let's see. The TPA is that people fail it because they do not understand the concept and purpose of this paper. So the purpose of this paper and the concept that is involved in this paper, as I've said, is in general, it's that which an attorney is expected to know. It's a general concept. The purpose of this paper is to test your understanding of dealing with various matters that may be brought to your practice. The other thing is that people fail to understand the drafting of commercial contracts. As I've said, if you're not from law school or you're from law school and you're not paying attention, it's worse. The third thing is that failure to understand the drafting of letters and clauses in contracts is also a disadvantage. So, what are the things that you have to cover when you are studying? First, some topics on company law, especially on business rescue and liquidation. When does each take place and in terms of what section? The pre-incorporation contracts. You must know also insolvency, things like the notice to sell a business, notice to advertise, etc., etc. The sale of a business as a going concern. Immediately you do this, you must know also the application of VAT, value-added tax. The approach of practitioners to prescribed claims in their practices. You must also know that. You must know various clauses in commercial contracts. Clauses such as renewal clause, rental escalation clause, right of first refusal, breach clause, suspensive conditions clause. You must know the sale of land clauses. You must know matrimonial law. They may ask you to explain to a client the types of matrimonial property regimes that we have. You must know the trust, how to trustees, beneficiaries, etc., amendments, types of beneficiaries. Also, you must know the provisions of the Legal Practice Act, especially on admission and readmission of legal practitioners. You must know the VAT clauses in sale agreements. You must know a portion of labor law. It depends on that year on what subject will they want to surprise you. But if you have a law school manual, it's easy to spot it because the law school manual will guide you on important subjects on labor law. For example, it may guide you on dismissal. It may guide you on unfair labor practices, like that. The law of cost. They may ask you to complete an incomplete bill of costs. You must know conducting business as a partnership, sole proprietorship, personal liability company. Which one is preferable? You must know the apportionment of damages, the calculation. You must know the ethics, the common law ethics and rules of conduct in attorneys' practices. On drafting, you must know that all agreements must have a causal event. Whereas Clarence Mangen has a YouTube channel, whereas the YouTube channel is in need of camera, whereas Mr. Cameraman has agreed to provide Canon camera, blah, blah, blah lens. Now, therefore, the parties agree as follows. 1. Parties. The lessee shall be so and so, the lessor shall be so and so. 2. Property. The lessor agrees to lease this to so and so and so, like that. So you can draft any agreement if you understand the COSA. That COSA, you will see it in agreement, starts with whereas. And then what happens when you draft clauses? Normally people fail clauses because they don't number them correctly for mark allocation. They just write a paragraph and leave it there. It's better to write it, numbering it. You say, because it's a clause that you quoted, that you are quoting, you can just do opening quotations and say right of renewal. Then you say 1, and then you say the lessee shall notwithstanding anything contrary in this contained in this agreement, the lessee shall have a right to renew this contract in this way. 1.1. By delivering a notice to that effect 3 months in the end, blah 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 blah. 1.2. Should the lessee fail to deliver this within this what period, blah blah blah, that right, this. Like that. And you put any whatever provision you want. 1.3. Should this lease be renewed orally, the right of renewal will not be incorporated in that oral lease. It's up to you what conditions you put. So you see, they are numbered, these things. You see the first one, he marks it. He sees the second one, he marks it. Third, like that. But if it's just a paragraph, you are not even putting full stops. A person doesn't even know. If they allocate a mark for one, they don't know where else to get the other mark. So it gives you an advantage if you have marked your things. Number your paragraphs also in letters. If they say draft a letter to client and all that, you must know that attorneys, they number their paragraphs in letters. Because even when a person is telling you about that letter, they're able to say at paragraph 3. But if the letter is just paragraphs and all that, they don't know which paragraph to point to. Be that as it may, that is all from me about paper 1 and 3 of the attorney's admission examination. I wish you nothing but all the best, and all I can say is that those who are organized, they always get it right. All the best, ladies and gentlemen, and thank you for watching. Please share and subscribe. Thank you.